NBC News White House correspondent Vaughn Hillyard joins me now. Also with us, NBC News senior Homeland Security correspondent Julia Ainsley and NBC News legal affairs reporter Gary Grumbach. In just a moment, we'll be joined by NBC News legal analyst Danny Cevallos as well. Gary, I'll start with you here. We're sort of looking at two legal tracks with this Alien Enemies Act case, right? There's the merits of the case, the merits of the act itself, and then whether the administration violated the judge's order that blocked its ability to use the act a couple of weekends ago. Talk to us about the purpose of today's hearing. Yeah, the Trump administration defiance is really just a sideshow to all of this. What we heard today was almost 2 hours of appeals court hearings where the government is trying to tell the appeals court and get the appeals court to stay Judge James Boasberg's order where he blocked the deportation of Venezuelans under the Alien Enemies Act. Two things really stuck out to me today. First is the level of concern that the Venezuelans did not get their day in court. That is something that was really important to Judge Millett. She kept saying, and she said, quote, Nazis got better treatment under the Alien Enemies Act. What she's referring to, of course, is just the ability to then appear before a court and say, hey, I am not part of the TDA, the gang, or perhaps they are, and then they, of course, would get deported underneath that act. The other part I thought was very interesting was this venue issue that they kept talking about, whether or not D.C. in a district court was the right place to have this case be held. Perhaps it should be held in Texas, and perhaps it should be held under something called habeas, which is when a petition that's filed in court by a prisoner saying, should or should I not be detained? All right, so still a lot of questions to deal with here. And sometimes we listen to these cases, which sometimes go hours long in these arguments, and we try to get an understanding of where the judges might stand on ultimately deciding these things. Any indication from what you heard today on what direction the court may be leaning and when they might actually issue a ruling? So this is a three-judge panel, so not everybody necessarily is going to agree here. Judge Millett certainly seemed like she was willing to not allow the government to have a stay of Judge Boasberg's ruling. Judge Walker, he's a Trump appointee, he did seem willing to want to allow the government to have a stay. Judge Henderson is the third judge here. Karen Henderson, she did not ask a single question during the entirety of the 2-hour hearing, so she is certainly the wild card in this case. All right, somebody to watch. All three of them are something to watch. Let me turn to Danny Cevallos here, joining us now. So, Danny, if the appeals court does reject the Trump administration's appeal in this case, help us understand what may happen next.
So the important thing here is this appeal isn't really about Judge Boasberg's at the district court finding out whether or not the Trump administration defied his order, whether people should be held in contempt. The narrow issue here at the Court of Appeals is really about jurisdiction. And even there are a couple different flavors of jurisdiction. On the one hand, and I just heard Lee Gallant for the ACLU arguing this issue, on the one hand, issues like TROs, temporary restraining orders, are ordinarily not appealable. You have a strange situation here where one side is arguing the TRO, that should not be appealed at all. But yet the other issue, whether or not there's jurisdiction over the issue of the political question. In other words, the Trump administration argues that this is a political question and the courts can't even touch our decision on this issue. I think that argument's a bit of a stretch, and my sense is the appeals court is receptive to the plaintiff's argument here, which is that it's not really the executive's purview to say on their own, subjectively, that something is a political question and unreviewable by the courts. It's for the courts to decide if the courts can't decide it. And that, I think, ultimately may carry the day. So, Vaughn Hillyard, let me bring you back in here. We've talked, obviously, about how the government lawyers are handling this case at this point. The political players in the Trump administration really are not backing down from some of the messaging that we've been hearing about this case in particular, right?
Correct. And you have seen the likes of Tom Homan, Kristi Noem, Pam Bondi, the Attorney General, as well as the president himself, gone out publicly and talked about the case. And in so many ways, this is the type of campaign that they ran in 2024, pushing back on the judiciary. And as the president himself last week suggested that these, particularly Judge Boasberg's a bad judge, and noted that he's not elected. Of course, that's not how the federal judicial system works. That is the independence and the separation of the judicial branch and the ability of a judge to act and ultimately make decisions without a fear of being voted out by the electorate. And that is where you have seen the president and his cabinet allies try to still make the case to the public public at large that they are simply trying to root out gang criminals in the United States that are here undocumented, and that it is the judiciary that it is getting in the way of their ability to do so.
All right, Julia, let me ask you. We know the Trump administration has been a little vague about details about how it knows that the people who were deported are actually members of this gang that we've been talking about. Any more insight, any new details about that?
Yeah, I think that was what was so striking, Aaron, is how little detail the Trump administration even seems to know about who is in prison, who they sent to that CICOT prison in El Salvador. Previously, when we've heard questions like that from Judge Boasberg, we've thought that it's because it might be secret, that they don't want to detail all of that. They've even thought about arguing state secrets. But not only were they not able to say exactly how they established that all of these people were part of the Tren de Aragua gang, but they weren't even sure how many of them had final orders of removal. If the judge had already ordered them to be deported, they could have been deported as just part of normal immigration process. Of course, it's unusual to send them to this prison, but they wouldn't have had to use that Alien Enemies Act to deport them. The reason they were using that was to try to circumvent the normal process and be able to, quote, summarily deport a whole group like you would, say, a foreign nationality if we're at war with that government. So we didn't get a lot of detail on that. But something I know even from reporting on TDA since it started becoming a problem last summer is it can be really hard to connect people and figure out exactly who's part of this gang. A lot of people could be victims of this gang. They could owe them money because they brought them across the border. They're very large in smuggling networks. And other people could have temporarily worked for them in order to get some money, but not be a big part of the hierarchy. So it can be hard to discern. Some of the tattoos might connect them. Some of the tattoos might not.
Danny, let me ask you, as we sort of look down the road here, who has the legal authority right now over the alleged gang members we're talking about here who are being held in El Salvador? Could the court order them returned to the United States at this point?
Possibly. I mean, there are a couple different, you're asking about two different courts right now. There's a proceeding in district court and then the appeals court. But I think it's important to note that even the challengers have said that there may be no barrier to seizing these individuals and deporting them, removing them through the ordinary removal process. This is not the ordinary removal process. This is the invocation of the Alien Enemies Act. And that is really what's at issue here. In the district court, it's about whether or not the Trump administration openly defied the court's order. At the appeals court, it's really the more legal issue, maybe the more important issue of whether or not this truly is a political question, one that the judiciary, the Article 3 branch, cannot touch because it is solely within the discretion of Article 2, the executive branch. So that is going to be a critical decision here for the appeals court on this issue of jurisdiction, not contempt. That really is for the lower court.
And Vaughn, we also understand that Homeland Security Secretary Kristi Noem is scheduled to visit El Salvador's prison, this super prison we've been talking about, later this week. What have you been able to learn about that trip?
Of reported abuses and a mass number of individuals incarcerated in one cell at a time. There is still a lot unknown. It's not clear whether Secretary Noem, to the extent that she is going to get a tour of this facility and have an understanding of what those abuses exactly look like and the extent to which those more than 300 Venezuelans or purported Venezuelans who the U.S. has deported to the El Salvadorian prison are being cared for. This is going to be the first of 3 stops for her on her Central America tour. She's going to be meeting with the president of Colombia as well as the president of Mexico, according to an aide to Secretary Noem. But for the secretary, this is a notable first trip here, and one in which she is seeking to highlight the relationship between the United States and the president of El Salvador, who allowed for these deportations to take place in exchange for a certain sum of money, but one that could potentially be used going into the future.
And Julia, I know you're also tracking this trip the secretary is going to take and the broader deportation operations that this administration is going to continue with.
Yes, and as we know, they could continue to deport people to this prison even while there's a temporary restraining order on the Alien Enemies Act if they can prove that they have final orders of removal. Something that came to mind, though, when Vaughn was talking is the moment when Noem was picked as Homeland Security Secretary. It was a really unusual pick. And something I heard from someone then during the transition was Trump liked the fact that in her book book, she highlighted that she shot her dog, the one that she considered untrainable, and he thought that showed she was tough. So if we're expecting a Secretary of Homeland Security to go down there and see the conditions and have a change of heart, I think really the point of this trip is to show the exact opposite.
All right, Gary, let me turn to you. We are looking at a couple of different cases here as well, right? There's another case where the Supreme Court is being asked to block a ruling to reinstate the fired federal employees that we've been talking about. What's your understanding of that? What's the scope of that request?
Yeah, so there's a number of these very similar cases. This one's out of the Northern District of California, where a judge said 6 departments worth of probationary employees must be reinstated. And it's not just they can be reinstated to administrative leave, which is what a lot of departments did and what the similar Maryland case allowed. This one said you have to fully reinstate them, get their badge access back, get their computers back, get their onboarding completely redone. And so the Trump administration is going to the Supreme Court saying essentially this lawsuit shouldn't have happened because the wrong people sued. Basically, a bunch of unions for federal workers sued, whereas in Maryland, it was actual states that were actually harmed, actually impacted by the federal workers losing their jobs. In this case, they're saying it was the wrong jurisdiction, it was the wrong people to sue in this case.
So they'll get a chance to argue and then a decision, but it could be a while.
The Supreme Court will have to, first of all, either approve or deny this application that they brought to the Supreme Court, and then they will have to schedule a hearing on this where both sides will get their day in court.
All right, Danny Savalos, I want to switch gears with you a little bit here, too, to a different aspect of the Trump administration's fight with the judiciary. The White House, we know, is telling the Attorney General to go after lawyers and law firms that bring what it calls frivolous lawsuits against the government. Is it possible to define what frivolous means, or is this really something that's being received as a threat to not take legal action against the government?
Yeah, most lawyers who do litigation have been involved. Well, maybe not many have been involved in actual frivolous litigation, but virtually all of us have received the threat of frivolous litigation. And it usually falls under a rule called Rule 11. And what happens is one of the litigants says, hey, we think your case is frivolous. But that's the adversarial system. We're sort of hired to say the other side's argument is ridiculous. Rare is it the case that a court determines that a case is actually, in fact, frivolous. And that's the point. It's one thing to allege something is frivolous, for example, under a rule called Rule 11. If you mention Rule 11 to lawyers, they're usually familiar with that being the rule that addresses frivolous litigation. But ordinarily, it is the court that determines ultimately if a case or a piece of litigation is frivolous. It's not for the executive or the litigants themselves to declare frivolousness and then proceed accordingly. So the fact that this is a unilateral determination, presumably it's going to be made about lawyers and their law firms, is problematic. In addition, it is the court that normally decides sanctions for frivolous litigation. It's not the executive that decides that litigation is frivolous and then goes after lawyers and their law firms. So this is deeply concerning. Obviously, I'm biased as an attorney myself. Nobody wants to be doing their job and then suddenly find themselves on the wrong end of DOJ because somebody has determined that what the lawyer's doing is frivolous.
So what's your impression then, and what's the impression of the larger legal community or the other lawyers that you talk to about whether this is intended to be a threat or intended to have a chilling effect on lawyers and the potential cases that they may bring on behalf of others against the government?
Yeah, here is how sacrosanct I see litigation and the court process. Consider this. The normal rules of defamation, in other words, if you say something false about somebody, you can be sued. They don't apply to things like court filings, and there's a reason for that. We want to preserve the safety, the sanctity of the court process so that you feel free to say things in court that maybe you would get in trouble for saying out in the public square. And the reason for that is to encourage full, frank discussion, litigation in the courts, and so that lawyers like me are not fearful of making allegations in the interests of our clients in court. And that is why this is really going to have a chilling effect against, admittedly, a small, I imagine, subsect of lawyers, those lawyers and law firms that the Trump administration is targeting. But you can imagine that they could expand it to a lot more lawyers. So, yes, this is concerning. Yeah. It's a chilling effect, and it shouldn't be happening.
All right, we will leave it there for now. Danny, we appreciate your analysis on this. Vaughn, Gary, Julia, thank you all for your reporting.
Thanks for watching. Stay updated about breaking news and top stories on the NBC News app or follow us on social media.